All right, I think we'll go ahead and kick things off. I am Anita Krug, Dean of Chicago Kent College of Law, and I am thrilled to see all of you here today for the latest installment of our Centennial Lecture Series, and to welcome our speaker today, Vince Warren, who is Executive Director of the Center for Constitutional Rights that's based in New York. And he's a well-known expert on racial injustice and discriminatory policing. His lecture today is titled Movement Lawyering in the Era of Black Lives Matter. And we are honored to have him join us today. There is much I could say about Mr. Warren, and I'll say some of that when I introduce him in just a minute. But before I do that, I want to say that Mr. Warren's work has been essential to ongoing and very necessary conversations and around building a more equitable and just society. And while Mr. Warren is the most recent in a list of very distinguished academics in our Centennial series, in my mind, he's one of the most important. His work goes to the root of what we are here for, our common mission in signing on to the legal enterprise. That mission is furthering justice, which includes doing all we can do to correct injustices where they are most pervasive and most challenging. So it is now my great pleasure to introduce Mr. Warren. Vincent Warren is a leading expert on racial injustice and discriminatory policing, and as I mentioned, is the executive director of the Center for Constitutional Rights. He oversees the CCR's litigation and advocacy work, which involves using international and domestic law to challenge human rights abuses, including racial, gender, LGBTQIA injustice, and he has had noteworthy achievements. And under his leadership, so I'm just going to name a few, the CCR successfully challenged the NYPD's stop and frisk policy and practice of profiling Muslims. The CCR under his leadership also ended long-term solitary confinement in California's Pelican Bay prison and established the persecution of LGBTQIA people as a crime against humanity. The CCR is now challenging the abuse of migrants at the US southern border, the Muslim ban, the torture of prisoners in Abu Ghraib, and the criminalization of transgender people, as well as providing legal and policy support to Black, Brown, and Native organizers across the country. The CCR is also still representing men in Guantanamo. Before joining the CCR, Vincent monitored South Africa's historic Truth and Reconciliation Commission hearings and was a senior staff attorney at the ACLU and a criminal defense attorney for the Legal Aid Society in Brooklyn. He is a graduate of Haverford College and Rutgers School of Law. Mr. Warren has received many awards, including the New York State Bar Association's Committee on Civil Rights 2016 Hayward Burns Memorial Award, the New York State Association of Criminal Defense Lawyers 2015 Justice Award, the Rutgers Law School Alumni Association 2012 Fannie Besser Award for Public Service, and the CUNY School of Law 2012 Distinguished Public Service Award. Please join me in extending a warm welcome to Mr. Vincent Warren.
Thank you so much for that wonderful introduction, Dean Krug. I have to figure out my password, so I can't talk at the same time. That is what I do. And it worked. It's a miracle. Thank you so much for having me. With your permission, I know that we have a mask rule here, but I feel that I'm both far enough away and uncontagious enough to be able to take it off. So thank you, just to be able to address you. Dean Krug, thank you for the warm welcome and for the wonderful conversation we had this morning. Thanks very much to Tasha Kincaid for the tremendous skill with which she organized the event, with which she organized me, and for the kindness that she has shown me and the staff at the Center for Constitutional Rights. And last but certainly not least, I want to thank Professor Atuahene for her brilliant and relentless work to unearth the devastating effects of repressive and relentless tax foreclosure schemes that is largely invisible to most of us, but is felt so deeply and a defining economic reality to Black, brown, and poor people in this country. And most importantly, for the friendship and support that you've shown me over the years. Thank you so much. And thank you all for coming in person and and virtually. I think amongst the things that distinguish this talk, if not for you, certainly for me, this is the first address that I've given actually wearing real pants in 2 years. And I'm very, very proud of that, although I'm a little uncomfortable. And I wanted to talk with you all today about the looking back movement lawyering in the context of the Black Lives Matter movement. And it's really a 10-year look. It is a 10-year look because Trayvon Martin was killed in Florida 10 years ago this month, and in some ways inspired and ignited a new level of activism, a new level of organizing, a new framework for lawyering, and a new frame to understand how our institutions can both compel discrimination and inequity or allow it, even if they're not compelling it. It's a good time to look back, as Professor Justin Hansford, a colleague that I met in Ferguson, Missouri, who's now teaching at Howard Law School, has he put it, citing Professor Derek Bell, that racial justice movements in this country have always been met with backlash. Derek Bell less than a decade before Jim Crow took hold. This framework continues to be relevant because within a decade of the end of the civil rights movement, the war on drugs ushered in a new era of mass incarceration. Less than a decade after the first Black president was elected, a virulent racist president took office. And as we'll talk about, in the 10 years since the killing of Trayvon Martin, it has produced both extraordinary change. It has produced new and emerging organizers with an insistence that no person or institution should be allowed to be either a perpetrator of or bystander to Black suffering. But it has also produced a tremendous backlash and retrenchment in the face and in the wake of that insistence. So I come to you from the Center for Constitutional Rights, where I've been the executive director for 15 years. The Center for Constitutional Rights was founded in 1966, essentially on a movement lawyer strategy. The first cases that we did were in Mississippi. And they were in Mississippi because not only was it the heart of where the civil rights movement was happening in the 1960s, it was also one of the most dangerous places within the South to do civil rights lawyering. In fact, when you think about litigation strategy, the litigation strategy that was happening in the South was largely do it any place but in Mississippi, because you're going to lose. And that the idea was that if you did it in other places, that you would be able to sort of either bring Mississippi along, or you can bring the entire South along and you can sort of carve out Mississippi or what have you. But the founders of the Center for Constitutional Rights, which included Morton Stavis, Arthur Kanoy, who was my law school one of my law school professors, and William Kunstler, the strategy there was to go to the fire and go to the people, where the people actually needed the help, places where other lawyers wouldn't go. And that has resonated with and has become a key part of the traits of CCR to this day. One of our first clients was the famed organizer, Fannie Lou Hamer. For those of you that have access to the internet and don't know the name Fannie Lou Hamer, I welcome you to Google it immediately. One of the most extraordinary organizers that the United States has ever seen. And we had the great fortune of having her as one of our first clients, in which we sued in Sunflower County, Mississippi, where Black people were literally turned away from being able to vote because they couldn't satisfy the test that they put on Black people and no other people in order to allow them to vote. And question number 16 on that test was, and I kid you not, how many bubbles are in a bar of soap? That was what the South looked like then. The Center for Constitutional Rights worked with the Black sharecroppers who insisted, who demanded that they have the right to vote, regardless of what risk it meant for them. And we were proud to stand with them. A note about where we are now, and it's important to think about movement lawyering, which we're going to talk about, in a political context, meaning that there are some lawyers that operate without regard to the political pressures of the day. They don't take a position. They say that we are nonpartisan. They say that whether you're right or left or blue or red, it doesn't really matter. What matters is the rule of law. That's not how the Center for Constitutional Rights thinks of it. The Center for Constitutional Rights is an explicitly left-oriented legal organization. And so as an example, while we think that the First Amendment is the foundational constitutional guarantee that allows us to do the things that we do, there are some clients we will represent and some clients we will not. And that's aligned with our political view. We employ an intersectional approach to the thinking of our work. And what I mean by that is, this is one of the things that distinguishes us from a lot of other organizations, that the intersectional approach that we employ mirrors the intersectional lives that our community partners live. And so that our approach considers the role of 4 key power structures when we do our work. Number 1 is structural racism. Number 2 is structural gender oppression and heteropatriarchy. Number 3 is oppressive economic structures, and number 4 is oppressive state power. And the reason why we use those frames is because, as for a lot of civil rights organizations, they have to figure out what their superpower is. And some of them we do voting rights, and other people say we do criminal justice, and other people say we do gender justice, and all of that is wonderful and it's great, and they do outstanding work that our colleagues do. But when you're in the community basement with folks in Louisiana who have just gotten notice that a chemical plastic plant is about to build a $9 billion facility on the burial grounds of their ancestors that the state of Louisiana has never acknowledged, those superpowers don't necessarily serve you well if you're trying to serve that problem. So what we do is we look at these 4 key structures, but we look at them in an intersectional way. So that way we don't get pigeonholed into doing one kind of work. So as if you're in Louisiana and a chemical plant is coming, you can't say that that has nothing to do with gender justice and families. You can't say that doesn't affect LGBTQIA or queer people. You can't say that it has nothing to do with economic justice, and you can't say that it has nothing to do with racism or state power. It has to do with all of those. And so by looking at it intersectionally, that we're sure that our litigation, the litigation that we work on, dovetails and doesn't siphon off and doesn't marginalize or compartmentalize the full lives and the full needs that our community members have. The last note about movement lawyering. It's an approach in which we partner with and legally represent or advise motivated and organized social justice movements or community groups. And that we do this to move their agenda and not to move our legal agenda, not to satisfy jurisprudence, not to identify gaps in the law, but to satisfy their agenda. And doing that requires tremendous trust that we have to build. It is on us to build that trust with our movement partners. It requires showing up, not where we are, but where they are. It requires, as I was telling a group of students this morning, if the first rule of Fight Club is don't talk about Fight Club, and the first rule of the Hippocratic Oath is first do no harm, the first rule of movement lawyering is don't take up too much space in your first meeting. Because being invited into that space where people are struggling with how to solve existential problems in their communities, the privilege of lawyering that we have can also be wielded unknowingly by us, because in the middle of that discussion, they might turn to you and say, well, what do you think we should do as a lawyer?
And I was telling the students this morning, that's the question that you cannot and should not answer. Because as soon as you say, well, here's what I think you should do, you might actually shift the strategy towards a litigation strategy, which may not be in their best interest and may not be what they want, but they're saying, well, if the lawyer said it, it's probably something that we should do. So the first rule is to show up as humbly as you possibly can as a lawyer. I don't know if we know too many humble lawyers, but as you can. And to listen, because what you will hear is you will hear emerging strategies, because impacted communities, every impacted communities has the exact answer for what needs to be done to end the oppression of their communities. They all have that answer. The challenge is that the answer that they have and the thing that needs to be done very often cannot be satisfied by filing a case. It cannot necessarily be satisfied by going to your congressman or your local representative. It cannot necessarily be satisfied by writing an op-ed. And so the goal is that if we listen to community strategies about what they want and what they need, then our job is to think as creatively as possible and as boldly as possible about how to make that happen in our lane, which is the law. The stop and frisk case. Dean Krug mentioned that we successfully litigated the stop and frisk case. And the only thing that I want to say about that is many of you have heard about it. And this is the case in which after a 9.5-week trial, our federal court judge found that the New York City police practice of stopping and frisking predominantly Black and Latinx people was unconstitutional. And it was a big ruling. It was a tremendous win. It was a lot of work. But what most people don't know, that case didn't actually start out of the brain of a lawyer. It started out of the brain of an organizer. And it started, the case was won in 2013. And the case actually started in 1999 when Amadou Diallo, who was an African immigrant, was shot by the police in the Bronx 41 times. And he was shot by the Street Crimes Unit, which was a particularly horrible unit that was non-uniformed. They basically were cowboys. They were going around throwing people up against the wall for guns and drugs, and they were just shooting people. And then, saying that we thought that they were a drug dealer, we thought that they were a rapist. And the community organizers said that, is there anything that you guys can do about the Street Crimes Unit? So we got together and we talked about it, and we litigated first the case that was called Daniels versus City of New York, which then changed to Floyd versus City of New York, which was the case that we ultimately won. The only reason why I'm telling you that story is that the origins of these cases are as important as the result. The results get written up in federal law books, if you're lucky, but the origin stories don't. And it's important to know that that case came to us as a challenge to lawyers to do something about a particular problem. Protesters, activists, and organizers. So when I say movement lawyering, what the heck am I talking about? What is a social movement anyway? And how do we know one when we see one? Well, I wanted just to throw out a couple of ideas. There's a difference between a protester, an activist, and an organizer. So when you think protesters, you can think about, I don't know, people driving trucks on the sidewalk in Ontario, Canada. You can think about people walking around wearing pink hats, people that are outraged and that they want to protest something that they think shouldn't be happening. We all have that right. We all have that ability. We all do it in our own way. Those are protesters. Activists are a little bit different. Activists are people that are making a point and making largely the same point, but they do it very often through symbolic actions that will challenge the country through the symbolic actions to change. So when you think about activists, think about Colin Kaepernick. When you think about activists, think about Bree Newsom, who climbed up and removed the Confederate flag. That's activists. Organizers can include both, but they are an entirely different animal. The organizers are people that think about the tactic of protest, the tactic of action, and they think about it in a broader strategy. that they're looking for change, and they deploy those tactics. They will organize protests. They will organize legal support for people that are activists, but they are organizing community to be able to make a broader statement and not just a symbolic one, but one that has some teeth. When the goal is to change a policy, and you have a recalcitrant legislator, there's only two ways that you're going to get that recalcitrant legislator to do what you want. One is that you are going to show this legislator that it is in his interest or her interest to do the thing that you want them to do. And the other one is that it is not in his interest to not do the thing that you want him to do. And that's part of where the protests and where the societal clashes come from. Because in some level, things have gotten so bad that the Black Lives Matter movement had to shake up and be able to move the people who were embedded in, wedded to the status quo, as harmful as it is, and get them to move. And sometimes that meant that you needed to have what people call mass turnups, mass protests, hundreds of people, thousands of people, not just because they're mad, but it has a specific purpose. There are specific targets for these. So the ecosystem of organizing is a complex one, and that as a movement lawyer, as a group that works with social movements, we have to be not only aware of these things, but we have to, at some level, adjust our legal strategies depending on what folks want. The last thing I'll say about lawyers and movements is that for those of you who are litigators, particularly those of you that do complex litigation, we think about litigation as litigation strategy. We think about the order in which things are going to happen. We think about what's going to go in the complaint, when the complaint's going to get filed, what are going to be the areas of law that we're going to argue, and in what order and with what language. It is an entire strategy. Organizers think of litigators as a tactical tool. We think of ourselves as strategists, they think of us as tactics. So if you think of organizing using 5 different tools, the law is only one. And so in order to be successful, then lawyers have to rethink their role, so that you actually need to be comfortable with being a tactic within an organizing strategy, as opposed to being a leader of a legal strategy and having organizers and communities follow you. That is actually the cutting edge of where civil rights litigation is now. And my mission, my goal, is to get lawyers to think differently about that. So 2013, I told you that we won the stop and frisk case. And that was in August of 2013. In September of 2013, I met 2 amazing people. I met the 2 leaders of the Dream Defenders, Philip Agnew and Ahmed Abu Znaid. And I met them in 2013 in New York. We were invited to breakfast. It was 8:30 in the morning. All of us were really, really super tired. And what I'd learned, and I did not know this, but they had started this group called the Dream Defenders. These 2 guys had started this group called the Dream Defenders in response to Trayvon Martin's murder. And I heard about them from a range of folks. I heard about them from Harry Belafonte, who I consider a mentor, and it told me that this was the type of youth-led movement that he was excited about, and he wanted me to get excited about. So what I learned after I met these 2 guys is that they had just finished occupying the Florida governor's Rick Scott's office for 31 days. Occupying the governor's office for 31 days. And they were demanding a special session in the legislature to repeal the stand your ground laws that were at play in Florida, and certainly at play within the context of Trayvon Martin's killing. So when you think about police protests and people moving to the streets, that happens. But organizers also have a big strategy, and the strategy is clear as to why they took that particular tactic in that particular way. Now, did they get Rick Scott to order a special session? No, they did not. And they ended the protest just days after we won the stop and frisk case. And I remember that they were young and they were incredibly humble. They also had that look of worry in their eye because they knew what they had to do next, but they didn't know what that was going to bring. And I read an announcement about why the Dream Defenders ended their protest. And the announcement said, "We have decided that we are ending the protest because we are starting a movement. And because of the Trayvon Martin killing and because of the activism and that was happening in Miami, that was the first time that the Black Lives Matter hashtag showed up after the killing of Trayvon Martin. And I'm going to be calling it for this discussion, the Black Lives Matter hashtag, because it is a hashtag. It is a social media device that is used by organizers to be able to galvanize folks, but it doesn't in itself create a movement. So when we talk about the Black Lives Matter movement, as a technical matter, people are generally thinking about anything that has the words Black Lives Matter slapped on it. When I'm talking about the Black Lives Matter movement, I'm talking about the movement formation that was built between Trayvon Martin's killing and Michael Brown's killing. In Ferguson, in 2014, 18-year-old Michael Brown was killed by the police. And the Black Lives Matter hashtag had been on fire. It had galvanized so many people. And in Ferguson, Missouri, the organizers, the local organizers in Ferguson, had been under siege by the police for 6 weeks. They had shown up and protested every single day, every day for 6 weeks, and met with the most egregious violence, met with scorn by the citizenry, met with recriminations from decision makers, but they showed up every single day. And think about this, 6 weeks, right? These are people, in order to show up on the front lines of the protest, they had to leave their jobs. People don't know this story, but these were not people that didn't have anything else to do. There are people that I met, and very few of them were professional organizers. They didn't work in social justice organizations. One worked in a pharmacy. Another one was a receptionist. A third person was a student. Young people that I met in Ferguson. And they walked that line. And not just because Michael Brown was killed. They walked the line because Michael Brown's killing was the final straw in an historic panoply of abuse that community had been met with by city officials and by the police. Professor Atua Hene illustrates in her terrific work, Predatory Cities, that Ferguson, Missouri is another example, like Detroit, as she talks about, of a predatory city. And what we mean by that is that when you look at what was happening at Ferguson before Michael Brown was shot, issuing 9,000 warrants on cases stemming in large part from minor violations, such as parking infractions, traffic tickets, or housing. People who have tickets and they get warrants and they end up in jail. This was a practice that had been happening regularly. They had a thing called wanteds, where the Missouri, the local police departments would have their own little system, and they would issue wanteds. If they wanted to talk to somebody, they would put it on the screen as a wanted, almost like putting up the wanted poster in the Westerns, and that any police officers in any of the 91 municipalities in St. Louis County could just pick up that person on a warrant, detain him, bring him to whichever police officer wanted them, and they just wail on him for 24 hours. This was what was going on at the time that Michael Brown was killed. So it is no surprise that people were on fire. It is no surprise that young folks rose up. And importantly, it was no surprise that the young folks that were doing this organizing had long since lost faith in people like me that had been doing legal work for 30 years, but had not managed to change anything in Ferguson County. There was a young man who was 15 years old at the time. His name was Low Key. Do you know why they called him Low Key? Because he was low key. Yeah, he was that guy. And Harry Belafonte was talking, a number of us were talking, and he said, I have a question for you all. And we said, what's the question? He says, how come you all ain't fixed this? And I mean, it cut me when he said it. It wasn't a simple question. It wasn't just an indictment on us. What it was it really showed that the methodologies that we were using to address this were unsatisfactory to the moment, to this moment in history, that we were actually not fulfilling the promise in the long line of people that have been doing this work to do our best, most insightful work in this moment. That was when the Center for Constitutional Rights began to shift its strategy to be more connected to the new organizers, the people that had just begun to walk the line. People didn't quite know what they were doing, that were figuring it out while they were doing it and faking it until they make it. This is when we invested in different ways. So we spent 5 weeks on the ground in Ferguson, my staff did, without filing a single case. Other organizations came in, they had their superpowers, there were First Amendment cases, there were governor whisperers trying to get the governor to fire this, and there were people that were talking to the prosecutor. We didn't file anything, and the reason why we didn't file anything was because the infrastructure in Ferguson, Missouri was so lacking that we needed to build trust in order to be able to, and give space for the organizers to come up with a strategy. And they did come up with a strategy that we worked with. And the strategy was the following thing, that in order to be successful, to change things in Ferguson, Missouri, we have to continue to protest. When we protest, they lock us up, but they don't just lock us up in the local jail. They drive us to any one of the jails in the 91 municipalities, and they drop us off in jail there, and they don't tell anybody that we're here. So we lose 20% of the protesters to who knows where every day. And we will not be successful until we figure out a strategy to get those people back on the line. And that suggested to us as lawyers, well, what we needed to do is to form a legal defense network. So the National Lawyers Guild and the Center for Constitutional Rights formed the Ferguson Legal Defense Network that worked with a range of community groups like Hands Up United, which was a coalition. And what we did was we recruited 100 attorneys, law students, lawyers in St. Louis to come to Ferguson, where we trained them on movement lawyering, and then we deployed them to the various jails that were there. And their jobs were to make sure that the people that were sent to these jails, they would note their medical condition, get them medical treatment, get them bailed out, and then bring them back. And that not only helped keep the line moving, but it also gave the organizers a tremendous amount of data about what the strategy was. These are the sort of the stories that people don't know of in Ferguson, but that's an example of a movement lawyering strategy where you couldn't possibly have thought about that on your own, but once you are faced with what the community needs, you figure out a way. Which brings us to defensive versus offensive work. So look, are we trying to materially change the conditions for Black people in America? Yeah. And will we be able to materially change the conditions for Black people in America by coming up with really great legal strategies like, I don't know, keeping protesters out of jail? No, that's a defensive strategy. It's a defensive strategy. And what we learned was that as organizers are really trying to organize for a transformation of the systems that repress, not a repeal, just a repeal of the law, not just a reform of the police department, a transformation around the question of safety. The way that if you talk to any movement for Black Lives organizer, they will tell you that if you ask people in your community what keeps them safe, they will talk about housing, they will talk about healthcare, they will talk about jobs, they will talk about education, and they will talk about those things that are lacking in their community. They don't feel safe because of that. And they will not say at the top of their list, we need more police. Given the choice between more police and more education, I don't even have to ask that question to you. You know how most people would respond in any community. So the transformation is then, how do we divest, either in terms of money and resources, but also in terms of our fealty, of our sense of security around the question of police, and how can we invest in Black communities? And embedded in that is also our societal fear of Black communities. I personally think that most folks in America, when they think about Black people, they're like, Black people are great. and discrimination happens. But when you talk about transforming Black communities, it's almost like they treat it like an experiment that might fail. And liberal folks were saying, well, maybe we shouldn't take such a radical approach, because what if the crime rate does go up? And what if these things do happen? It's almost as if people are afraid to wholly invest in the vision of what the Black future looks like, and they want to partially invest in a gradual vision of what the Black future could look like. And the young folks have had it with that. They're not about that. And so that's our organizing strategy that has now become the litigation strategy. So then we're thinking, if it's a transformational, forward-looking vision for the world, why are we on the defense? And the reason why we have been on the defense for 10 years has been for the reason that Derek Bell taught us. It's the permanence of racism. I'm a Star Wars fan, something that you need to know about me. And the episode 5 is called The Empire Strikes Back for a reason, because the rebels were winning in episode 4. And when the Empire strikes back for Black people, it slaps back so viciously that it shocks the American conscience. And the only way that you can have that kind of clap back without shocking the American conscience is by continuing to criminalize and dehumanize the people that are taking the action. So that when we talk about protesters and we talk about organizers and we talk about activists, the thing that they do have in common is that they are constantly and continually vilified and criminalized for the purposes of maintaining social control of Black people. So it's almost as if the thing that the Constitution says that we are allowed to do, that protest, the thing that all of us should hold dear, it doesn't work. It has never worked for Black people. The idea of a protest being a peaceful means for change means that if it threatens material things, I'm not talking about burning down buildings, but if it threatens the materiality of white society, it becomes a dangerous thing. And then all of a sudden, all of these criminal laws attach to them. That's what we're pushing back against, the criminalization of activism. And the way that I think about it, it's the criminalization of freedom fighting. We've seen that in the context of South Africa. I saw that in spades when I was doing that work. And it's also the criminalization of transformation. The idea that Black people can only win if white people don't lose. And if that's the paradigm that we're swimming in, if that's the conditions under which I'm litigating and under which we're all advocating, how is that different from 1865? It's not. The Movement for Black Lives is an organization of a network, an ecosystem in which Black organizations have come together with Black constituents and have really identified some of the key priorities for change that they want. And the work has shifted from the idea of protests, and they can still get people out onto the streets. You're not seeing as many protests, and certainly not as many protests by Black people. Because remember in 2020, when the government was calling the feds and the FBI and people were getting disappeared, those are mostly white folks. That's a success of the Black Lives Matter movement, by the way, BTW, is that it's encouraging and galvanizing white folks who understand that unless they show up differently, things are not going to change. But that gets criminalized as well. We heard a lot about Antifa over the last several years. That's code for white people, and terrorists is code for Black people when they do the same thing, which is protest. So what have we learned? Where do we go from here? The success of the Black Lives Matter movement is seen in very concrete ways in terms of how we think about the idea of disruption, for example. What, as a society, are we able to tolerate? Should we be tolerating in terms of disruption? To a lesser degree, but I think a significant one, the fact that police officers can get convicted for shooting unarmed people. It's a change. It's It hasn't happened systematically in the United States since the founding, and this is a new thing, but that's actually not what we're really here for. We're actually here for the question of transformation. And the movement lawyering aspect of this requires us to cut off and to carve off little pieces of the work so that when a litigation strategy is successful, it buoys and amplifies the goals of the organizers. And when it's not successful, it does the same thing. The last thing I'll say about movement lawyering is the success without victory concept. And the success without victory is something that we talk about at CCR, and that's where you don't win the case, but the fact that the case was filed and that people know about it actually has an impact on the way that the world thinks. And so the case that we did was a Freedom of Information Act case on behalf of the movement group Color of Change. It's a national organization. And Color of Change, working with the Black Lives Matter activists, had been hearing from them about mass surveillance that had been happening. The FBI, they had stingers, they had all sorts of mechanisms and moving around. They were arresting people, they were infiltrating the Black Lives Matter movement. And that they came to us and said, what can we do about this? And we filed a FOIA request. And in the FOIA request, about surveillance on particular activists and organizers, we got documents back. One of the documents referenced something called the race paper. And we're like, tell us more about this race paper. We were successful in the context of FOIA litigation of getting a copy of the race paper. And I have also seen copies of Guantanamo detention logs that were redacted less than the race paper. Every single line of the race paper was blacked out. It was 2 or 3 pages long. We were not actually successful in getting a court to give us an unredacted copy of the race paper. But the fact that there was something called the race paper that the government would not unredact was one of the most powerful tools to be able to galvanize Black folks, but a lot of folks around the question of surveillance. And so that it was a defensive move that we actually turned into through media and through other things as a way to be able to shift the debate. So the question wasn't so much, what are these kids doing on the line? But the question is, what is the FBI coming up with here? And and in some ways, the fact that it was redacted is more powerful than if it had been opened up. So these are the types of things that are still in motion with respect to the Black Lives Matter movement. It is very much on the defensive now, but it is moving into positive spheres. The reason why you're not seeing people protest so much now is because there are a list of policy demands and a list of bills that are pending before Congress right now that really are about transformation. So that last 10 years, the movement has grown and it has grown up, as well as movement lawyering. Our strategies are as diverse as ever. We never know what's going to be coming next week, but our goal is to move from the defensive to the offensive over the next 10 years. Thank you. We have a few moments for questions.
Just raise your hand.
Wasn't the Phil Donahue show filmed in Chicago? Phil Donahue, was that filmed here in Chicago? No? And I know Oprah, but I was just reminded with the microphone.
So thank you very much for talking about an intersectional approach. And that's certainly something that I think a lot of us as professors talk about. The problem with an intersectional approach is undoubtedly, is that there is no constitutional protection for class, and law does not recognize class. Of course, some litigation, which you're very well aware, got close to the point of having the Supreme Court look at class. So when you talk about structures of oppression and you can't get at class or really capitalism on a big scale, what do you do?
Great question. The big challenge, as you know, is that our constitutional system is really based on civil and political rights and not social and economic rights. And so, of course, all the things that people think are important, you actually can't really super get to in a constitutional framework. What we do in that situation is that's where intersection helps us. We have a case in Buffalo, New York, which will have the best caption of any Supreme Court case when it goes to the Supreme Court, if it goes to the case. The group that we're representing is called Black Love Resists in the Rust. It's the name of the group, and it's against the city of Buffalo. So I'm imagining the Supreme Court case called Black Love versus City of Buffalo. In that case, we are challenging, I know it trickles in, but it's a funny joke. The case is about the rampant and discriminatory ticketing within East Buffalo, which is largely Black. They've basically cordoned it off and they just ticket everybody in their cars. They give them a ticket for each tinted windows, thousands of dollars. And so it's a policing case that is framed in the 14th and 4th Amendment. The advocates were like, yeah, and this goes to Professor Atuahene's discovery or book as well, which is like that it is a mechanism to generate revenue off the backs of Black people. That's a different cause of action, which we're actually not doing. But what we did was we filed it, and we're talking about 14th and 4th Amendment. The advocates, when they're talking to city commissioners and other folks, are framing it as an economic thing, because that's really what the city government thinks about. They're thinking about money. And so you can get a both and if the court papers are really focusing on the solid constitutional issues, but the framing is actually broader than that.
Hi, thank you so much. Chris Schmidt, a professor here at Chicago Kent. I was wondering if you could just pick up on that last point of your talk, talking about pivoting the Black Lives Matter movement from a defensive to some sort of offensive position, maybe moving ahead, and talk a little bit more about what you see as the role of movement lawyers in that particular phase, because I see the movement lawyers defending the protesters. But if we're trying to look at the long-lasting transformational change that might emanate from the Black Lives Matter movement, you talked about some legislation that's pending, but are there other components of this offensive pivot where you're going to see movement lawyers playing this creative role?
That's a good question. So there are a number of ways in which it happens. And I think one is that there is a role for lawyers in framing. For example, we do a lot of letter drafting to different entities where we underscore the legal issues, but we're actually trying to move a policy piece. So we do some of that work. What we're thinking about is we're thinking about a series of Section 1985 lawsuits, which are super hard to prove, but these are lawsuits in which you have to allege a conspiracy you can allege a conspiracy to deprive people of their constitutional rights. And the advantage about thinking about it as a conspiracy, even though it's a hard thing to litigate, is that it shifts if the conspiracy is that there is essentially a constructive abandonment of Black communities with respect to a particular set of issues. You can isolate one or two constitutional pieces, allege a conspiracy, and then the framework begins to shift to the actions of the various parts of government that are working together, either wittingly or unwittingly, to be able to do this. And so there are a series of cases that we've been thinking about. There have been constructive abandonment causes of action that we've been thinking about. Honestly, we've been thinking about litigating cases under the 13th Amendment, which is a hard thing to do. But again, but not just litigating them with respect to Supreme Court jurisprudence, but actually looking at some of the legislative intent behind some of the things in the creation of the 13th Amendment, which are revelatory. Like, quite honestly, when you look at that body of thinking and what was intended, it would actually have, had it come to pass, would have solved, or at least gone to solve, a lot of the problems that we're thinking about. So again, everything that I talked about, constructive abandonment, Section 1985 litigation and 13th Amendment litigation, do not fall into the category of easy wins, but they do fall into the category potentially of success without victory, because people don't know that there is an area of thinking from a number of years ago that actually was about the transformation of society now that Black people were in it as freed folks. And that's sort of what we're thinking bold along those lines. And if we win, you have to buy me drinks.
Hi, thank you so much for being here, and thank you to all the faculty and everyone that made this possible. My name is Ashley. I'm just a 1L, but I'm so excited to hear your talk. I was an organizer for a long time with immigrant rights communities, so hearing you talk about being humble and listening to the leaders is just amazing. I wanted to ask if you have any advice for those of us who, maybe have been on the outside for a long time, but now we're stepping into these roles where we're really wanting to go on the inside. I'm interested in public defender role, for example. It's very different, but the movement is big. There are people who are on the outside, people who are on the inside doing change. So I'm wondering if you have any insights or advice there.
Yeah, and thank you, and I appreciate the organizer love, and I hope I got the definitions right. But when you say outside and inside, I take that you're talking about working outside of these legal institutions and now thinking about working inside them.
Right. So, people who are maybe going into government, people who are going into, public defender roles. I don't know. There are even people who see themselves as part of the movement who are in prosecutor roles too. Sorry, I'm on the defender side, but it's kind of a different mode. And I'm just wondering if you have any insights or if you've done any work with people on systems change, administrative changes, stuff like that.
Sure. So it's important. What I'm not going to say, or if I say it, I don't mean it. I'm not going to say it's important to have good people on the inside. That's not what I mean. That is actually true, but that's not what I'm going to say. What is good about it? And I'll speak as someone who is a public defender. If you ever want to get a sense of how manifestly unfair and how stacked against defendants and humans the system is, be a public defender. And I don't mean that the experience should only be a negative one, that you can, that's not what I mean. What I mean by that is that the system is understanding how that system operates is the key to getting good results for your clients. Understanding how that system operates is the key to helping organizers and community rethink their strategies around how they approach the criminal system. And we have to remember that, so I very much support that. And I think that's a very good role. And I also think that, we're also experimenting. And I think that anybody that says this, I want to try this area of law, and if it's a government job or if it's corporate job or or public interest job, they should 100% try it. The challenge is that we all have economic realities. And so that's where you get stuck, because if you think about where you are economically, you can only try so many things. And maybe the thing you're trying is law school, and I need to come out with a job making some money right now. So with all of that having been said, I think that it's important that people begin to move into spaces where they feel like they can learn something. You can always leave and do something else. Plus, and I will say about public defenders is that in the uprising that happened in Baltimore after Ferguson, it was the first time that we saw public defender organizations actually participate in the movement strategy. And that was led by lawyers, not the leadership. The leadership was like, we have city contracts, we can't jump in and do this kind of stuff. But the lawyers really insisted, and they enrolled themselves in representing protesters that were coming through and connecting that to the movement, which is something that they had not done before. So there are tremendous opportunities to do that.
So thank you, Vince. As you can all see, he's just an extraordinary individual, an extraordinary speaker, and just thank you for coming. And I just want to thank this. You started your question by just saying, "I'm just a 1L." You're not just a 1L. Thank you for being bold and standing up and asking your question. That was excellent. So mine is just about, I love what you said about getting on the offense and getting away from the defense. And I also, to add to that, I want us to think about violence and about the different kinds of violence. I think the Black Lives Matter movement was really propelled by physical violence, right? We see these Black people getting lynched by police officers, right? Protest in the street, right? It was a reaction to physical violence. And I think the next step of the movement needs to be really integrating other types of violence. There's a whole lot of financial violence happening as well. You know, as you know, my work shows that Black and brown people pay 10 to 13% more in property taxes on average than whites for the same bundle of goods. And so there's a lot of financial violence. And the problem with financial violence is, you know, it's not recorded. You can't, you know, you can't see it. It doesn't provoke that, you know, visceral response. So if you could just talk a little bit about the Black Lives Matter movement as it matures. Do you see it maturing from, you know, again, this embrace or somehow being kickstarted by physical violence to expanding to really addressing other types of violence?
Yeah, I totally, I appreciate that the question, and it is actually happening. And one of the revelatory things for me was to be thinking about the police reaction as state violence, to be thinking about how Black people are treated in a variety of contexts that don't involve the police as state violence. The state violence frame is a powerful one. And I want you to all, if you haven't heard that statement before, that I want you to sit with it, because it's powerful, and it challenges us to think about exactly what you said. Yes, you know, the 1033 program has mine-resistant tanks going through the street of Ferguson. We all think that's a bad idea. We should not be like, what are we going to do with all the stuff now that we pulled out of Afghanistan? Oh, let's just deploy it on our streets, right? We don't want that to happen. But the level of state violence is not related to, is not limited to that type of physical violence. And the folks in the Black Lives Matter movement talk about this all the time. It's not gaining resonance, but it is a very, very important role to play, and a very important thing to do. And that the relationship between physical state violence and economic violence and other types of violence is that the state violence gets rolled out particularly to keep people in states of other types of violence. It is a social control mechanism. It is actually not a response to criminality. It is a social control mechanism. And in fact, you can tell when you're winning. The bigger the tanks are, the more you're winning. And that's a cold comfort to a lot of people and a lot of colleagues that I know that have died and been injured. But as a movement strategy, going back to the Empire Strikes Back, when they strike back with that level of physical violence, that you know that you're beginning to seep in to destabilize, again, people's fealty towards the idea of law enforcement as the best possible thing we could do to be able to support Black people. So I'm with you on that. Thank you all very much. It's really been wonderful.
Thank you so much. And thanks all of you again for joining us. I think the lecture was wonderful and a wonderful conversation with you. Thanks so much for your questions.